Uh, so I would like to introduce Kevin, and he's got here with his law partner, Ellen. And he has, by the way, an excellent book on estate planning where he takes a very complicated subject and really reduces it to simple English and very understandable English. And I hope he will tell you how you can acquire one from him. It's superb, very good book. So, Kevin, without further ado.
Thank you, Fred, for those kind words. I do have a book, and if you do want to purchase it, you could call my office, 312-831-0005, and my secretary, Angel, could give you the info on that. There was the question regarding Social Security and when you take it. The answer is, if you could tell me when you're going to die, I'll tell you when you should take it. Technically, when I've run it, it takes 11 to 12 years until you start losing. So in other words, if I took it at 62, and I reached 73, 74, I would have been better off delaying it. But it's a numbers game. Everybody's different. You have to run the numbers to see what would I get if I was at 62. When I retired, the full retirement age is 67. What would I get at 67? And then the full benefits would be 70. So basically, at 67, if I wait to 70, every year thereafter, I get 8% increase. So it's a big numbers game. What a lot of people don't know about Social Security, if you're 65 and you have a child under 18, your child can get Social Security. Yeah, interesting, huh? So that's a little fun fact you could tell anyone you know who has a child under 18. Okay, so we're going to try to go over here a little bit about on estate planning. The first thing I'm going to talk about is what our firm believes should be objectives of your estate plan. So one is your financial protection. Okay, we want to make sure you have your finances in order. 2, carry out your intentions. 3, avoid or minimize death taxes. I have so many people come to my office and say, hey, Kevin, I got to do a trust because I got to save on taxes. That's the tail leading the dog. You should let your estate planning attorney, and I say estate planning attorney, the law changes constantly in this area. And so you should go to someone who does this on a regular basis rather than a general practitioner. And that estate planning attorney should carry out your intentions in the most tax efficient way. You shouldn't be worried about the taxes. Your attorney should be the one implementing that. 4th is financial protection for your loved ones. When I was a young attorney, I used to never worry about this because I said, hey, you want to leave your estate in any manner you want, that's fine. But many times, and I'll give an example, I would tell you, okay, you're going to give it to an individual who may not handle it right. Why don't you just give away 25% of your money today? And you would say, I'm crazy. So that's why you want to make sure you have financial protection for loved ones. 5th is to make sure who you want involved is involved, whether that's during your life when you're disabled or at your death. And 6 is a liquidity problem. So farmers are asset rich, cash poor. And you may have investments that are not liquid that may cause some issues upon your death. So these are the objectives we believe that you should satisfy with your estate plan. Now, if you're ever going to pay attention to me today, this is it. Title is extremely important to what's going to happen to your assets at your death. You have the greatest estate plan, and it's useless if you don't have your assets titled properly. So what do I mean by that? If I have property in my name alone, if I have a will, the executor will receive it and administer it according to my will. If I have no will, the court will appoint an administrator, and Illinois will create a will for you. Illinois will say what happens to it. Okay, so that's for any property in your name alone. If I have life insurance or retirement plan in which John Jones is the named beneficiary. So I have a wife and my will says, honey, I love you, I leave you everything. If John Jones is the beneficiary, I have a contractual agreement with that life insurance company that says when I die, It goes to John Jones. Doesn't matter what my trust says. Doesn't matter what my will says. Okay? What if I have life insurance or retirement plan, which the trust is the beneficiary? Then my trustee is going to handle that and get administered according to my trust agreement. If I have life insurance or retirement plan, which all the beneficiaries die before me, or there's no named beneficiaries, we're back up here. If I have a will, the executor receives it. If not, administrator receives it. What should be going through your mind right now, anybody that has a retirement account, an IRA, a 401k, a 403b, a 457 plan, any retirement account, any life insurance, go home, look to see if you have in writing who the beneficiaries are. If not, get that from the financial institution. Get it in writing. Don't let them tell you verbally. Get it in writing and put it with your estate planning documents. Many years ago, I had a client. I did a great estate plan for him. He did a trust. We did the will. I helped him fill out the beneficiary forms. And it was him and his wife, and he died. And I told the financial institution, which I'm sure many people have an account with, I said, oh, great, take the IRA, roll it over to his wife's IRA, and we're ready to go. And they said, Kevin, I would love to do it, but there's no beneficiary on file. I said, they can't be. They've been married for almost 40 years. And I know he would name his wife as beneficiary. So I went to the wife and said, hey, do you have a copy of the beneficiary designation form so we could show it to him? They did not. It was large enough that we had to go through probate. And one of the advantages of you're going to find out on a trust is avoid probate. So what happened? What I believe, well, what he did do is, which a lot of seniors do, he transfers his account because he could get a better interest rate over here. And I believe he did fill out the beneficiary form, but I couldn't prove it. But the institutions gobble each other up and the documentation gets lost. So that's why it's important that you have the written evidence. If I had written evidence that he had confirmation from that company that this was the beneficiary designation, I present it to him and say, no, at this time, this was the beneficiary. You tell me what happened after that. But I didn't have that. So you want to be certain you have in writing who your beneficiary is of your retirement accounts and any life insurance. Okay? Now, what if I have property in joint tenancy with the right of survivorship? So it says Kevin Fitzsimons and Robert Smith as JTWRS, joint tenancy with right of survivorship. I could have this on a bank account. Again, my will says, honey, I love you. I leave you everything. That immediately goes to Robert Smith. So there's also a misnomer that you cannot disinherit your spouse. That's not true. Okay? Because I could do everything by either joint tenancy or beneficiary form and disinherit my wife, Deb. The only thing I couldn't disinherit her from are qualified plans. The 401ks, the 403bs, 457s, because she would have to sign off on my beneficiary designation. Okay? So again, the only reason why I'm saying this is I could have a perfect will or perfect trust, but if I do not title my assets properly or have my beneficiary designations properly, it's not going to go the way I thought it was going to go. What about property and tenants by the entirety? This is for those of us who are married and are principal residents. Okay? Upon my death goes my spouse, I'm happy. Divorce becomes tenants in common. We'll talk about that in a minute. No longer my principal residence. It's joint tenancy goes to my spouse. So A and C both go to my spouse. What's the difference? Now, as I start giving these talks more and more, it starts to realize the younger crowd doesn't understand when I call this the OJ rule. I call it the OJ rule, OJ Simpson. If you remember back, they couldn't get his Florida house. It was protected. Well, this is the same with tenants by the entirety. If one of the spouses is sued, the creditor can't get the house as long as you're married and it's your principal residence. So upon your death, the creditors could get it because you're no longer married. So it just provides extra creditor protection. Okay. Property and tenants in common is what I call the poor man's partnership. So it says Kevin Fitzsimons and Mary Smith, not as joint tenants and right of survivorship, but tenants in common. My one half is as if it's in my name alone. So if I have a will, goes according to my will. If I have no will, then an administrator is appointed and it goes according to Illinois law. Mary Smith's half, I have no control over. It goes according to Mary Smith's. That's why I call it a poor man's partnership. A lot of times, let's say a brother and sister own a rental property, they may own it in this fashion. Okay? So how your assets are titled is going to determine what happens at your death. So let's do an example here. I always tell my clients when they create a trust, it's a 3-step process. The first step is an hour and a half, 2 hours. I meet with them, I get their intentions. And then the next process is I draft the documents, we review it, and they sign them. The third process is you gotta change title to your accounts. So instead of the account being Kevin Fitzsimons, it would be Kevin Fitzsimons as trustee to Kevin Fitzsimons Trust. Now I tell you, I could give you an estimate for what it cost me to draft the estate planning documents. I cannot give you an estimate what it costs to change title of your assets because every institution has a different system. I don't know how long it's going to take me. I tell you I'm going to charge my hourly rate and you go, Kevin. No, thanks. I'll handle it myself. And then you don't do it. So for example, you have all this great, you have a trust, you did a will, you did your property power of attorney, you did healthcare, but you have life insurance payable to another. It doesn't matter what these documents says, it goes to the other. Okay? Pension plans payable to another, same home joint tenancy another. Any of those kind of assets. So I would say about 15 years ago, I had a son come into my office and there were 4 kids. He was named as beneficiary of a life insurance policy. And he said, what should I do? And I said, well, under the law, it's yours. Now, his father's will said everything equally to the children. Okay, so he got it. But I said to him, if you do this, your siblings will not talk to you. Your siblings will not talk to you, most likely. So he thought it through and said, hey, Dad must have wanted me to have this for some reason. So he took it. What subsequently happened is he had kids and none of his siblings recognized the children. Who's at fault? The father. The father didn't communicate. Did he really want his son to get it? If he wanted his son to get it, he should have said that. Could easily said as well, hey, I have a life insurance policy. I'm leaving it to my son. I have my reasons. Just, honor it. At least then maybe his children would be talking to each other. I have no idea whether the father really wanted that son to have it. He was the eldest son. Did he just completely figure an eldest son? And this is the other thing I hear all the time. Oh, I'm just going to name my one child. My one child will take care of all the other ones. No. That's a disaster. Okay? So again, make sure you have your assets titled properly. So here we have Mrs. Smith. She has daughter A, daughter B. She has ABC company stock 50, XYZ 50, and 2 CDs, 100,000 each. Mrs. Smith wants each daughter to receive an equal amount. What happens at her death? ABC company goes to 60,000, XYZ goes up to 125. Why? It could be Apple, Google, whatever your big stock is. Certificate of deposit number 1 is 10,000, 2 is 50. Why is this 10,000? Positive way of thinking is the CD was maturing and Mrs. Smith needed money, so she went to that CD. Negative way of thinking is daughter B lives near mom, knows her sister's going to get this one and says, Mom, let's use this one first. Okay? So what ends up happening is daughter B gets 175, daughter A gets 70. That's not what Mrs. Smith wants. So you tell me, Kevin, there's no way Mrs. Smith would do that. She would put them all on. So she does that. So she has assets in her name and her two daughters' names. And it says joint tenants right of survivorship. What happens? The unexpected. Daughter A dies before Mrs. Smith. Last person standing wins. Daughter B gets everything to the exclusion of daughter A's children. Mrs. Smith really would want daughter A, her grandchildren, to get daughter A's share. Okay? Now, what could happen is, like I had, is life goes the way it's supposed to, and the children survive. So, many years ago, before the real estate crash in 2008, 2009, I had a gentleman come into my office, and he was the son. He said, could you help handle my father's estate? I said, sure. And he shows me the deed, and the deed has father, son, and daughter on it in joint tenancy. I told him, we got to sever this right now. You got to sever it. I got to have me draft up a new deed. And he goes, why? I go, you walk out of my office today and get hit by a bus, it all goes to your sister. Kevin, my sister wouldn't do that. She would give my share to my kids. And I said, let's say you're correct. What happens is that's a gift from his sister to his children. That has gift tax consequences. She might not be able to do it in a year. In maybe several years she can get it done. Okay? Also, they're married. It could happen that his sister says, well, we got a beater, you got a Mercedes, we got a small house, you got a big house. Mom and dad didn't care about the grandkids, they cared about the children. And she takes it off. He goes, Kevin, my family's not like that. We're good, everything's great, don't worry about it. I go, okay, fine, I told you. 6 months later, he calls me up and says, draft that deed, sever the joint tenancy. I said, what happened? He said, we've had multiple offers on the property. No offer is good enough for my sister. Emotionally, she couldn't let go of the property. So he ran the risk for 6 months that, God forbid, something happened to him, his kids would never see any of that real estate. So I am not telling you how to title your assets. I'm telling you to know how they're titled and what happens. Also realize when you put somebody on your account as a joint tenant, their creditors have a right to that property. You have a bank account, there's $100,000 in it, it's all your money. You put your child on as joint tenancy, your child has creditor problems, they can grab that money. That was common in the 2008, 2009 real estate crashes. A lot of children's real estate was underwater. And then you had the fear, uh-oh, they're on mom or dad's account. Are they going to grab it? So realize that when you do it in joint tenancy. I'm not saying not to do it. I'm just saying realize the consequences and make sure it's correct. Okay, now I want to go a little bit over trust and what's the advantage maybe of a trust versus a will. You can have probate even while you're alive. And I'll go through an example. If you have a trust, you can avoid that. If you have a trust and you title your assets into your trust, you avoid probate at your death. You can better cover a situation where you got a beneficiary's immature or spendthrift or incompetent. If you own two properties in two states in your name alone, it's well worth getting a trust. So let's say, for example, I have a home in Illinois in my name alone, and I have a condo or a home in Florida in my name alone. If I die, I have probate in Illinois, I have probate in Florida. You're paying two attorneys to go through probate. It'd be cheaper to have you do a trust and put both of those properties into the trust. It's a means of segregating your assets. So if you have a second marriage, it's a way to keep your assets separate from your spouse. More privacy. A trust is not a public record, a will is. That's why we always hear what happens to these actors or these sports figures. You find out what they did with their will. It's because it's a public record, where a trust is not. Administration is a little bit less expensive because you're going to handle it while you're alive, you're basically retailing your assets. And for a married couple, there's significant tax savings. So there's a lot of advantages on doing a trust. Now, who's involved when you create a trust? There's a person called the grantor to settler. That's the person who creates a trust. That's you. They transfer legal title to the trustee. That's you. So I transferred from Kevin Fitzsimons to Kevin Fitzsimons as trustee to Kevin Fitzsimons Trust. I administer on behalf of the trust agreement for the beneficiary, which is you. So while you're alive, you're the grantor, you're the trustee, you're the beneficiary. Now, I have 3 boys. Okay, so in all my examples, unfortunately, I have to say my wife predeceased me. So I got 3 boys. I always hear that I have to treat all my children or all my loved ones the same. No, it's a bad idea. You could treat them equally, but not the same. We're all different, okay? So I say at my death, put it in trust for Jason. Why? Well, Jason really hasn't figured stuff out. He hasn't got his plans together, so I want to keep it in trust. I put it in trust for Ben because he has no children right now, and I want to make sure it goes to my grandchildren, whatever's left over when he dies. I leave Niels outright. Why? So his 2 brothers get in trust, he gets outright. Why? He's a whiz kid. He's got everything organized. He's got his estate plan. He's on top of the game. I don't have any worries, so I have him go outright. That's what I mean by not treating them the exact same. They can give each the same amount, but they don't necessarily have to have the exact same way of receiving their property. Okay? And then this is my example. So when Ben dies, since he has no children, I make sure it goes to my grandchildren, Jason and Neil's children. Okay? And that's the way I can provide. If I give it outright to Ben, I don't know where that money's going to go. So that's why I might want to keep it in trust, because I'm ultimately deciding what happens. Okay. Now, the first thing I said was you could have probate while you're alive. So what happens is, if I have a trust and put all my title, my assets in the name of my trust, then the successor trustee takes over. If I don't, for instance, I had a nephew come in and says, I have to be appointed guardian of my aunt. This is what you risk when you don't do it, the trust. You're risking that the individual that's going into court that has to be your guardian, I have no idea if that's who you would have picked. You're also, the court's going to appoint an independent guardian ad litem. An independent guardian ad litem is another attorney who's going to go out and talk to you and see if you are disabled. So now the aunt's paying for 2. She's paying for me and the independent guardian ad litem. Once I get the nephew appointed, he has to post a bond. So she's going to pay it. It basically is an insurance policy that says if the nephew takes the money, it goes back in. And then we had to get permission to change her residency, okay? And the reason why that is the court wants to make sure that it's a place where her loved ones and family are. Now, if you do not have a trust and you have assets in your name alone, the only way to avoid this is the property power of attorney. Financial institutions can either elect to accept it or not. And as Alan has recently pointed out to me, there's been a new change in the law because many financial institutions were not honoring property power of attorney. But the lawyers believe the way they change the law is going to make it even more where the financial institutions will reject it. And the reason why they're rejecting it is they don't want the liability. If they end up putting your agent on the account and it wasn't proper, they're on the hook. When you do a trust and you open an account in the name of the trust, they have accepted the trust agreement. They've already accepted it. You're disabled, the successor trustee takes over, there's no question involved. Okay, so that's one of the advantages of a trust. Now, your trust is created by your own limitations on your own creativity and what you want to do. So these are some things that you should think about on beneficiaries. Do you have any that are minors, need long-term care? Are they knowledgeable in handling finances? Are they physically or mentally disabled, wealthy, spendthrifts? I'm going to go through all these. If you're worried about the undue influence, if you're worried about the daughter-in-law, son-in-law, then you want to put it in trust. Okay, so let's go through some examples. This is where it's amazing how many issues come up under this. Your personal effects, not a large value, but oh my God, do they cause fights? Okay, because it's sentimental values. So you might have told a certain member of your family you can have that painting and you forgot. Then you told another one you can have that painting, you forgot. Now they both think they're getting a painting. Okay, so what are your solutions? If you want someone to get something, you have to put it in your will or trust. I want you to get this particular painting. You got to put it in here. Okay, if you put it in there, it's legally binding. The other option is prepare an outside list. So a lot of times I'll have clients will say, well, Kevin, I might change my mind. And if I change my mind, I have it in a trust or a will, I got to come to you to amend the trust or amend the will. I don't like that. So then I tell them, okay, I'll put in the document that you may create an outside list of certain personal effects that you want to go to certain loved ones. And I know this may not be valid under Illinois law, but I want my executor, my trustee, and my loved ones to honor it. And knock on wood, I've had everybody honor it. I always tell my clients, put in your handwriting, sign, date it, so your loved ones can see it's you, and they usually follow it. So that's another solution. Or you could do a lottery. I'm one of 7 children. You take numbers 1 through 7, 7 through 1, and you just keep going. You have all the stuff out there and everybody picks what they want. Okay? But again, if you're not clear, this could create a lot of problems, even though it's not a huge sentimental value. I had a colleague, that's all they were fighting over, 2 brothers. And he told them, you're going to spend more on legal fees than this stuff's worth. I don't care. So it was his way to get back at his brother. Which is sad, you know, the lawyers only win. Okay. What if you made a loan to someone? Okay, so I have 3 boys. Let's say I lend Ben $300,000. And I have $1,500,000 when I die. If I say that loan is forgiven, then I have $1,500,000, they each get $500,000. If I say, no, that loan's considered part of my assets, I have the $1,500,000 plus the $300,000 note. I have $1.8 million. Each child gets $600,000. Ben, here's your first $300,000, a promissory note. Here's the other $300,000 cash. Jason, Neil, you each get $600,000 cash. So you need to be clear what should happen to loans. And do not tell me, Kevin, they'll never know. They always know. If it's a loan, treat it as a loan. Get a promissory note. Get the kid to sign it. Get it in writing. If it's a gift, you're doing a gift tax return. They're going to see it's a gift. But be clear. This is where I always blame. I blame you. You as the decedent. You need to be the communicator. If you're not the communicator, you're just going to have, your legacy is going to be your loved ones not talking to each other. You need to communicate. What is it? And be honest with yourself. If it's a loan, it's a loan. And make a list of when the payments are made. If you don't ever expect them to pay it, it's a gift. Stop kidding yourself. It's a gift, and say it's a gift, and then decide, is it going to be an offset when you die or not? But you got to be clear on that. Okay? Same for joint tenancy property. I might have one of my children on there because they're helping me pay the bills. Then your trust or will should say, hey, I have this in for joint tenancy, but it's for convenience only. It's considered part of my estate. So an example, if I had a $300,000 account when I died in joint tenancy with my son, Ben, he would get it all. Because that's what the law says. It doesn't matter what my will says. But I could say on that remaining 1.5 million, we're dividing. No, add that back in. Ben already got his first 300,000. You got to be clear on what you're intending to do and set it forth clearly. Okay. How do we solve problems via trust? We're going to talk about minor beneficiaries, disabled beneficiaries, spendthrift beneficiaries. You're worried about someone who may get divorced. You want to decide who the eventual taker is? Don't worry. I know I'm going fast. I'm going to go slow in a minute. Education trust. So life goes on. It's sad now. I can't say my boys are minors. They're all in college now. But let's say they're minors. Okay, when they're young, you need to understand this. A minor cannot inherit property. A minor cannot inherit property. You name your grandchild as beneficiary of an account, and that grandchild is 13. That grandchild cannot get that property. What happens is somebody has to go and be a guardian over that asset on behalf of that grandchild. So literally, your child would have to go into court, get appointed guardian of that asset to administer on behalf of your grandchild and report to the court every year. So that's why they cannot get it. You would leave it in trust for them. They cannot get it outright. Okay? So that's important to understand. Now, as I say, I have 3 minor boys. I might say, keep it all in trust as one pot for the boys. Trustee, I'm going to let you do what I would have done. You decide who needs what. I may have put the 2 older boys through college. The younger boy I didn't when I died. Now you may be giving more on behalf of the younger boy than the older boys. Trustee, you decide. And then I might say, when the youngest hits 25, okay, now divide it. So that's one concept to think of it. The other way is I could have just said, when I die, divide it in 3 equal shares in trust for my boys. Well, Neil, who's the youngest, he's using his inheritance to pay college. My 2 older boys, Jason and Ben, I paid their college, fair or unfair. That's what you would decide. So you might just have one big trust and say, when the youngest hits 25, divide it. Now, when I say children, loved ones, it could be grandchildren, it could be anyone. I'm just trying to give you a concept of what you might do if you have a minor beneficiary. Okay? Now, what about disabled persons? I have 3 college buddies who have 3 brothers at Misericordia. And the families would always disinherit these children. I really shouldn't say children because they're near my age, but anyway, these children. And I had a battle with one of the moms telling her, no, you can't do that. And she had the same concept I was telling you before, where if you name one beneficiary, it'll take care of the other kids. And she's like, no, I'll leave it to my one daughter and she'll take care of them. I'm like, no. If that daughter ever has credit problems, that stuff's gone. You have no idea what the situation is going to be like when you die. So instead, you create a trust for that child who's at Misericordia, and a trustee has discretion to pay income or principal for that child above and beyond what the government might provide. So you look to the government first, then this trust. That way they still get their government benefits. But they need things too. They need to go on vacation. They may need a special medical care that the government's not going to pay for, or an education. This trust would be able to take care of that. So instead of cutting them out, you just leave it in trust for them on their behalf. And this would be for a grandchild, anybody who's disabled. That's what you want to do. Okay? Now, what about if you have a beneficiary that has credit problems? So I had a client who came in and asked me to administer his estate for his brother, and I told him, no, we're going to walk away. And he said, no, I want to get it done. This gentleman had 25 credit cards to the max and didn't have assets. And he got a credit card 6 months before he died. And I was like, oh, good, credit cards companies got screwed, but really you and I get hurt by that because that's how they make up their money. But a person like that can't receive an inheritance. It would just go to the creditors. So instead, you say income and principal shall be distributed to the beneficiary as you set forth, whatever you want to say, for their rent, for et cetera. What that happens is they don't have what we call a striking order. The creditors can't come and say, give me the money out of trust. I know he can get assets out of it. He can't. So I, as trustee, would go to that creditor company. Hey, you willing to settle 10 cents on the dollar? I'll give you 10 cents right now, or I'll never make a distribution out of his trust. And so you're hoping you can work with the creditors to knock that down. Okay? Again, you got to give the trustee the power to determine whether or not distributions are made. Now, when you have a situation like this, what should be going off in your bell is you got to have a very good trustee. Okay. Someone who's going to stand up to the guy who's going to go, Kevin, money, 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 money. That trust is for me, money, money. I know I got credit problems, money. And you got to have someone who goes up and says, no, it's not what it's for, and you're not going to get it. Okay. So, like a lot of times, some clients will say, I'll name the sibling. I don't know about that. You sure? What's the relationship like? Are you going to destroy that relationship, et cetera? Okay. What about if you have beneficiaries who's divorced or may become divorced or undue influence? Those of us who are married, we're the problem spouse. The other side of the family thinks you're a problem spouse no matter how great you are. Trust me. Okay. Okay. So if you're worried about that, you wouldn't leave it outright to your child or your grandchild because otherwise you're worried about the spouse getting it. So you leave it in trust, and that spouse would not have any right to it. It would be all for the benefit of your child. So again, what you would have to do if you're in a situation, you can't have your child as trustee because you're worried that the spouse is dominating, so you got to have somebody else. Okay? That's the key to make it work. All right. Now, what about if you want to decide ultimately where it goes? So prior to having kids, I have an identical twin brother. So if you're out there and someone's rude to you, it's him, it's not me. So I used to leave in trust if my wife wasn't around for him, but he's single, no kids. But I wanted to say, hey, whatever was left over, I wanted to go back to my nieces and nephews. So that's why I would leave it in trust for him. If I leave it outright to him, I have no idea who he would give it to. Okay? So again, all his life he gets a benefit from it, but I say what happens at his death. Okay, so that would be a way to allow a loved one to be a beneficiary, but you ultimately decide where it goes. Educational trust. You could set up an educational trust for a class of people. Let's say it's the grandchildren. Okay. Set forth how it comes out. What are the terms? I might say, hey, congratulations, grandchild. You made it into Harvard, but you're getting what it costs to go to Illinois. Okay. Because I want it to last for all of them. Okay. And I had a client. She had a terminal condition. She set up one of these. She had no kids. She set up all for her nieces and nephews, and they could only use the income. And reality was, her family had done well, and she felt that they did well by education. In reality is, the nieces and nephews don't need it because she had wealth and her siblings had wealth. And probably even great nieces and nephews didn't need it. And this thing will go on forever. So it'll be 4 or 5 generations down that to learn about this woman who set it up for them and their family to have education. There's medleys of way you can do it. Now, you may come to me and say, hey, Kevin, leave it 100%, or just leave it outright to my child, or leave it outright to my grandchild. And I say, no, let's not do that. Let's put it in trust and give them the right to withdraw 100% of it. And you say, Kevin, why would you do that? Well, there could be an unexpected event. You and that grandchild are in the car, you died, the grandchild has a brain injury. Now this trust would be set up to take care of that grandchild. Or you have no clue that that grandchild right now has marital problems. And by you leaving in trust, you protect it from the divorce. So it's just a way to give flexibility to your loved one if they should need it. If they don't need it, they could just draw it out and do it as they deem appropriate. Okay? Now, you also should consider, like I said, there could be a problem where your loved one's not financially mature. So like my boys, I wouldn't give it to them right now. You know, they're in college. God knows what would happen to that money. So probably going all out of bars and everything. So now what you might say is, I might say, okay, Ben, Jason, Neil, you could draw a third at 30, a third at 35, and balance at 40. Now, I've seen it go as high as 55, 60, 70. Why? They usually have a chemical problem, alcoholic or drugs, and they're hoping that when they get to that stage of retirement, they clean themselves up and they'll have something for it. Okay. Powers of appointment. You can put in trust flexibility. What happens at your death? It's what I call the Monday morning quarterback provision. So I put in a trust agreement, hey, it'll get divided 3 ways upon Deb, my wife's death, assuming she survives me, 3 ways equally in trust. But I could give her the power to say, hey, Deb, you could change any way you want amongst our descendants. You can give more to one child. You can give some to the grandchildren. Why am I giving that flexibility? Between my death and Deb's death, it could be 15, 20 years. Something could have happened in between. Neil, that kid I was telling you, smart as can be, he's the next Bill Gates and says, I don't need the money, Mom. Leave it to my brothers. Okay. God forbid one of them becomes an alcoholic or drugs, then she could adjust on that. Okay. So it just provides flexibility. Okay. I'm not going to go through the marital deduction because we don't need it. But here's one thing I will tell you on this. So the rule is you can leave an unlimited amount to your spouse and it's not subject to any estate tax or gift tax. Now, as Ellen and I had just dealt with this week, there is a caveat. Your spouse has to be a U.S. citizen. If you're not a U.S. citizen, this doesn't apply. Okay. But in my example, U.S. citizen. So when Bill and Melinda Gates were married, here's $1 billion to you, honey, here's $1 billion to you. It doesn't matter. It can pass each other, no gift tax consequences. So you came in there and you're listening to my talk and you say, Kevin, that's too complicated. Forget that stuff. I'm drafting a will. Honey, I leave you everything. Okay. So I have 2.5 million. And I said, Deb, I love you. I leave you everything. So I get that marital deduction. I have 0 left. This 13,990,000, what is that? That's the amount you can give this year during your life or your death federally, not have any gift or estate tax. Okay. So now my wife has 2 million. I had 2.5. She dies. She has 4.5, 13,990,000. There's no tax, right? Wrong. Good old Illinois. Pay them 143,000. So for Illinois, if you have 4 million or more, every single dollar is taxed. Every single dollar. Okay. And everything's included. Your home, your life insurance, your retirement accounts, everything. When you're trying to get to that figure of 4 million. Versus if I did this trust and I say, Deb, everything that I can do tax-free, federal or Illinois, I'm shoving over here and I'm leaving you nothing. So Deb, you got 2 million. We don't pay any Illinois tax, save 143. But you're like, wait a minute, Deb's not a beneficiary of this. Yes, she is. I put it in what we call a residuary trust. I make her the beneficiary. It's just not taxable when she dies. So those of us who are married, that's what we're trying to do. We should never pay a tax when the first spouse dies. And we should try to shield, if we can, in Illinois, 8 million. Okay. You can more easily do this through your trust. You try to do it through a will, it's much more complicated. And as I tell my clients, most lawyers charge by hourly and how long it takes us. If you give me all this stuff that you're saying I have to do in a will, I'll tell you the will will cost just as much as a trust, and you're better off doing a trust to have more flexibility. Okay. Now, let's go to wills. Do you need a will? Yes. To make sure your property is distributed according the way you want it, not Illinois law. Address unique family situations like we were talking about, spendthrift, alcoholic, whatever it is. Name guardian of your children. Any of you that knows of someone who is a minor child, they need a will. I don't care how poor they are. I don't care how rich they are. They need a will at least to name a guardian if something should happen to them. Who's going to raise their kids? Okay. And then you need a will to minimize, eliminate estate taxes and avoid the bond requirement. Just like I was telling you when, if you're disabled and somebody has to go into court and be appointed your guardian, if you have a will and it doesn't say I waive the bond requirement, then your executor has to buy an insurance policy, a bond. So usually you want to say in your will, I hereby waive the bond requirement so that it doesn't have to happen. Okay. What happens if you do not have a will? Are you happy? Probably not. Okay? Half to my surviving spouse, half to my descendants if I have no will. Do I like that? No. I want it all to go to Deb, right? And then when my boys were minors, I don't want it to go to minors because they can't get it. But Illinois is trying to figure out what most people would want. If I have no descendants, everything to my spouse. Okay, I'm okay with that one. If no surviving spouse, everything to my descendants. Again, that's a problem because the boys are getting it outright. And what if they're minors? I don't want them having that stuff. They just get it right away. Now, if you have no spouse and no descendants, what happens is your parents each get a share in your kids. So again, I said I was 1 of 7. My dad survived my mom. So my dad would get 2 shares and my siblings would each get a share. So there would be 8 shares. I'm 6 siblings, each get a share, and my dad gets 2. So that's what Illinois is trying to do to determine, to make a will for you, basically is what they're doing. Do you need a will if you have a living trust? Yes. It's called a pour-over will. What it's saying is taking any asset that's in my name alone and put it into my trust. Okay? That's it. Now I'm ready for questions.
Thank you, Kevin. We're going to take questions from the auditorium first and then from Zoom.
If the 2017 tax reduction act is not reiterated by the end of this year, doesn't that 13,900,000 whatever thousand go down to 5 or 6 million?
Yeah, so the question is, right now today, you have 13,990,000. And the way they passed the law last time was it didn't balance. It has to be neutral. And so they could go 10 years out and then they say, hey, pretend we never passed this bill and go the old way. And this gentleman stated, so then what's going to happen is the old law was 5 million, but it was indexed for inflation. So it'll be cut in half. If they do nothing this year federally, it'll be 7 million next year. Now, I hear this all the time now. Everybody thinks, oh, it's because the Republicans got complete control, it's going to happen. Don't believe it. I mean, only takes 4 of them not to do it. We used to make prognoses all the time. I stopped in 2010. Our whole profession said in 2010, there's no way Congress will let the estate tax go away. And they did, because they couldn't agree on anything. And we're in the same state today. So I'm not making any predictions, but I'm telling you, don't rely on it. For those who may be worried about this and are going to make gifts, don't wait to December. The attorneys are going to say, can't do it. We don't have enough time. This is crazy. So if you really are worried about that issue, you should start thinking about and planning on it now. But yes, it'll cut down in half.
Is there a difference between a living trust and a revocable trust?
No. So a living trust and a revocable trust are the exact same. It's just different terms they use. In a living trust, you can change it at any time as long as you're competent. So you can change it any time during your life. Versus an irrevocable trust is one where you're saying it cannot be changed. When you die, your living trust becomes irrevocable because you're deceased, so it can't be changed and revised.
Can you talk to transfer on death documents?
Okay. So transfer on death documents are similar to beneficiary designation. Now, I assume when you're talking about the latest thing on transfer on death, you can draft a deed that says at your death, here's what happens to your home, transferred as follows. And so think of it like a beneficiary form if you're doing an account. Okay. What? I'll be there. Yep.
Yes, Kevin, we have a question and a follow-up
Okay.
from the Heather. Heather is asking this question. I have a will and a living trust. They need to be reviewed and probably updated. Would you accomplish this by amending the living trust or would you write a totally new trust instrument?
Okay, so you have a trust, you have a will, and the question is, do you amend it or do a whole new trust document? And that depends on what the needs are. So you'd have to see what you need to change and why. So I always tell my clients every 3 to 5 years or a major life event, marriage, divorce, birth, death, you should review your estate plan. I have many clients where I just do an amendment because they have minor changes. If you have major changes, then I would totally do a in total or a complete amendment. Okay, now I'll get you in a second. I want to get back to her on this transfer on, yep,
Go ahead, please.
okay, on this transfer on death. Okay, so you could do it through, like I said, on your deed. You could do this, make beneficiary designations in your IRA, and you could do it as on your accounts. I am not a fan of that being your estate plan. That being your estate plan. You're not worried about your will, you're not worried about your trust, because I'm going to name beneficiaries on every single thing, and that's going to take care of the problem. Here's why I don't like it. You better be on top of those beneficiary designations all the time. Where it really gets messy is I have clients say, I'm going to give Susie this account and George this account, et cetera. And I said, that's great. Do you know you're going to have that account when you die? Do you know what the value of that account's going to be when you die? Do you know these are going to be equal? You know, and I had a gentleman recently in taught me on this, and he had 3 rental properties. And he was giving each child a rental property. And I kept saying, no. And he said, yeah, don't worry, I'm never going to sell. He's never going to do it. What happens? He gets sick. They got to sell one of them. He's going in assisted living. I'm running assisted living. I finally convinced him we got to go back to which I told you, equally to the kids, not designating the assets, because now one kid's going to get less and they're going to be fighting with each other. That's the danger. If you're not on top of beneficiary forms, you could really screw it up if you don't know what the balances are when you die and who's the beneficiary. So that's all I want to stress on that.
Okay, follow-up question.
Yes.
If you have a living trust that is outdated, minor way, because you want to change the beneficiary, you had 2 children, you want to make one instead of both
Yeah.
equal benefit trustees rather. Can you do that manually? And let's say you wanted to add a grandchild that was born after the trust was made. Can you make minor changes on your trust by?
Oh, no. Oh, no. Thank goodness. Yeah. Do not mark your original documents. Don't cross something out, add a new beneficiaries. Big problems. You're going to make all the litigators happy. You'll make Fred happy. Okay? Because what we don't know was, what the court has to figure out, did you want to revoke that whole instrument? Did you just want to make that change? Were there other changes? Don't do it. You have to do it via an amendment. So you have to do an amendment, a document that's going to be drafted, hopefully by your lawyer, and that amends the terms. So for instance, I would say, I hereby revoke Article 1, and I insert the following in its place, and it would say that, okay? Now, this drives me up too, just so you know, as we get, when you're in this profession long enough, unfortunately, you see everything. And so I stopped being a punching bag. And I'm just bringing this up because he said, hey, what if I wanted to come in, instead of the 2 children, only one child's going to be the beneficiary. If you're coming to me, I'm going to say, that's great. We're having a family meeting with all your children and you're going to tell them what you're doing. You know, and if you don't like it, go somewhere else. Because what happens when you do it, and I used to do it when I was younger, I'm the punching bag. You told my mother, you know, and I've been cussed at and everything. And I said, okay, if you don't have the courage to tell your kids, I'm not doing it. And so that's all I would tell you. Because as an attorney, you always worry when someone's older and all of a sudden they make a big change. Whoa, what's going on? Why? Yes,
My question is,
it's on.
my question is very simple. First of all, it's a great presentation.
Thank you.
However, there's a lot of information to assimilate. Do you have a handout that we can take with us so that we can study it?
I don't.
This is being recorded, just so you know, and it's going to be available on the website, the
Yeah.
North Shore Senior website. But go ahead, please.
So, yeah, so it's on the website. As Fred said, I get it that this thing's a lot. that's why I create this book. And so, and it's for purchase, but you could call the office and if you want, then you can read on your own and get it all. Because it is a lot. And do I have a long waiting list to see me? Unfortunately, so I also do tax preparation. Yeah. So now, yes. After April 15th, not so much.
There was a question online also, if you do you do visits to senior homes?
I don't anymore. I used to, but it was so time consuming. So yeah, unfortunately, I do not.
We're bumping into pizza time in 5 minutes, so the pizza's delivering some, but we'll take other questions that may be here. Anyone else have a question? I'm gonna check. Okay,
Speak loud enough to use. Maybe supposed to be don't know how to use it. We have a number of preferences that are not specifically in our trusts, but they are things we'd like to have our children or grandchildren respect. One of them is weird, but not that weird. I said, yes, we'll pay for college, undergraduate, but not a red cent towards liberal arts or humanities or anything that cannot clearly and definitively prepare you for the real world.
Okay. And is it
Can
valid?
we do that?
Yes.
Because I put it in just on a written sheet.
Oh, no. You can do it, but it has to be via a trust document or your will. So you got to remember when I had the presentation, you're limited by your own creativity on what you could do. So I'm going to give you an example where a gentleman, and this was in the newspapers, gentleman said, you cannot, if you marry outside of our faith, you're done. You're no longer a beneficiary. A granddaughter, the gentleman was Jewish, granddaughter married outside the faith. She was cut off. She went to the court and said that's unconstitutional. Said, nope, you can do what you want. As long as you're not saying it can't be race, gender, et cetera. But yeah, you're limited by your own creativity. You could say, no, you got to go to this college or you got to have this major or whatever. You can do it. It's got to be in your document though.
In another state and you move, do you have to record the trust in the new state?
can you repeat
Okay,
the
I'll repeat it.
question?
Yeah. So the question is, if you had a trust on another state, you move to a new state, do you have to have it recorded in your new state? And the answer is no. So we have what we call the conflicts of law. Every state has to honor another state's law. So if it was valid in state A and you moved it, so it was valid in Florida, I moved to Illinois, Illinois has got to honor it. Okay. Now, sometimes people will say, okay, I want to make sure and look if there's any unique laws in the state, but just because you're moved does not mean your documents aren't valid.
Okay, I think it's time for pizza. Thank you ever so much, Kevin.
Thank you, guys.
Wonderful. And by the way, I highly recommend his book. It's Kevin, would you tell him what you charge for the book? It's very modest.
So I charge $40 now, $40 for the book.
$40.
Yeah.
It is worth every penny.